Hey everybody, we're gonna get going on the next set of notes. Um, we'll be posting this pretty late on Wednesday, so we'll get going right away so we can get this going. Okay. All right. So forensic science, we're still um, looking at legal considerations. That's the live session we did this past um, Monday and Tuesday. So I'm going to go over that, and this is the recorded version of that. So our learning objectives are to explore the Fourth Amendment and recognize what legal search and seizures are. We'll talk about a few landmark cases, including Fry, Miranda, and Daubert court cases, two of which you'll be looking at as far as your homework goes for Friday. You'll be kind of looking into a couple of these, and we'll go over those in the next slide or so. And then we're going to understand how these landmark court cases have determined the admissibility of evidence in the courtroom. Okay, so again, the assignment for this Friday, I want you guys to look at Fry versus the United States and Daubert versus Merrell Dow Pharmaceuticals. Write a brief summary. This doesn't have to be really long like some of our previous writings where we were writing 500 to 1,000 words. Each case should be no more than 100, 150 words. So when you kind of put that together, you're looking at a 200 to 300 word summary of these two cases, right? So you'll write a brief summary on the two landmark cases, include all the merits of the case as well as the decision, and then discuss any appeals that were made along with the decision of the appeal. And then briefly discuss why the cases were important to forensic science, especially when we're talking about admissibility. And we'll kind of go over that last part with the last couple slides of this set of notes. All right, so let's go ahead and get moving. So what are legal search and seizures? Well, this is important for forensic science because obviously, if we're going into a crime scene, right, as a crime scene investigator, and we're collecting evidence, we want to make sure it's done legally. If it's not done legally, if we're not kind of following the um, outline of the Fourth Amendment and what a legal search and seizure might be, well, then there's a good chance that the evidence that we collect and work hard to collect might not be admissible. It'll be thrown out. It won't be usable. So to avoid the exclusion of evidence in court cases due to illegal search and seizure practices, the removal of any evidence from a crime scene must conform to Fourth Amendment privileges. In order to protect the rights of the people, there must be probable cause before a specifically described piece of evidence um, at a specific site can be seized or taken into custody, right? So this has to be done under the authorization of a court-issued warrant. So let's kind of go in this, and we'll look at some of these, and there's going to be a lot of terminology in here. So we'll go through some of the terminology. What is a for example, what can be probable cause, and we'll talk about warrants, and we'll talk about maybe some of the um, things that won't require a warrant that we can still search, and we'll go through some of those things. So the first thing we want to look at is the Fourth Amendment. So an understanding of the Fourth Amendment of the United States Constitution is relevant for search and seizures, and it's critical for any investigator, any crime scene investigator, anybody that's looking at evidence, and really any law enforcement official. The Fourth Amendment simply states that it's the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And it shall not be violated, and no warrant shall be issued but upon probable cause. Support by oath and affirmation, and particularly describing the place to be searched and the persons or things to be seized. So that's the Fourth Amendment. And you see some things in there where we're talking about probable cause and stuff like that. So we're going to kind of go through a lot of that and discuss what all of that means, okay? So what are the guidelines for legal search and seizures? Well, again, you need to have a warrant, and that warrant has to be issued only if there's probable cause. So the courts are bound by the rules and they can only admit evidence that has been obtained constitutionally. Thus, legality of a search must always be kept in mind during any investigation. Now, the good news is most crime scene investigation teams aren't going to show up to a crime scene until the warrant has been, we've basically secured a warrant to search that scene. So most of the time, if you're working as a crime scene investigator, you're not going to be worried too much about going and getting the warrant. Usually that's been done ahead of time, usually by investigators or detectives or a DA or somebody has gone and got a warrant, and we can go ahead and go in and search. So when we're looking at this, a search warrant has to be issued. That's the first way, right? So we have some guidelines here, and the first and main one is, and 9 times, probably more than 9 times out of 10, you're going to be doing a search, and there's going to be a warrant in place for that search to happen. However, there can be some other instances where a warrant isn't necessarily um, needed. So let's look at a few of those. We can search, or law officers can search, when consent is given. That's perfectly fine. And sometimes it's not the crime scene investigator that's going to be collecting the evidence. It could be a patrolling officer, right? So, I'll give you a couple examples of this as we go through these one at a time. But the main one that I think of when we're talking about consent is maybe somebody's pulled over for a traffic violation. Maybe they ran a stop sign or something like that. The officer pulls them over, and during the questioning, maybe they get an inkling that something's wrong. Maybe they see something amiss. Maybe they smell, something that might be considered an illegal drug or something like that. Um, or maybe they smell alcohol in the person's breath and think they might have been drinking, or something kind of gives them an inkling that something might not quite be right. So they can simply ask, hey, do you mind if I look in your vehicle? And if the person that's driving the vehicle gives them consent, says, yeah, go ahead, well, then they obviously don't have to go get a warrant. And then anything they find, they can actually, if it's an illegal substance or, something that could constitute that a crime has taken place, or maybe, a law was broken, then they can collect that as evidence. All right, so there's another one. An officer could stop a suspicious person that they might believe is armed, and then they can do what's usually called a pat-down or a frisk, where they actually search the person. And that's fine. And then the search could be incidental to a lawful arrest. So let's go back to a traffic stop. Let's say this time the person's swerving all over the world or all over the road, and they're pulled over, and they check to see if they're impaired, and they, maybe they do a breathalyzer and they find out the person is over the legal limit, so they're going to be arrested. Now, as soon as that lawful arrest is going to occur, usually the suspect's going to get patted down to make sure they don't have anything that's going to harm them or the officer, and then they can also search the vehicle. And we'll talk about that a little bit more in detail. And then the other time that you might not need a warrant is if an emergency exists. If you hear gunshots in a building, obviously you don't have to run off and get a warrant before investigating the gunshots. So let's go through a few of these, and we'll talk about, again, a lot of terminology in this set of notes. So let's talk about how a search with a warrant works. So technically, according to the Fourth Amendment, all searches are to be conducted under the authority of a warrant. Now, to obtain a warrant, officers must appear before a judge, and they have to establish probable cause. And that basically, it has to be very specific. They have to be able to tell that a location contains a specific type of evidence that might lead to a specific type of crime, and they have to, identify the exact space or exact people maybe that they want the warrant for. So let's talk about what probable cause is. Probable cause is more than a reasonable suspicion. Probable cause to search requires that a combination of facts make it more likely than not that the items sought are where the police believe them to be. So probable cause is what would lead a normal person, right, a reasonably cautious person, to believe that something is connected with a crime and it's on the premises. So how can you establish probable cause? Well, there's several things, right? Maybe you have eyewitness testimony. People are coming in and saying, hey, this certain house at this specific address, they have a meth lab. They're making methamphetamines in the kitchen. Okay, and it could be just informants that are telling them this. It could be maybe an undercover officer that has went and investigated it. Maybe they can back this up by looking at, or making a, kind of observing the house for a while and noticing that, hey, they're bringing in materials that would basically be connected with a meth lab, with the raw materials that they're using to make the methamphetamines or something like that. So once they've established that, right, once they've established that there's probable cause, then they can get a warrant. Now that warrant must be served promptly. They can't get a warrant in 2020 and then go investigate the residence in 2025 because, well, obviously the meth lab might not be there anymore. But it also keeps officers from going back to the same location over and over again over the years just because there was a meth lab there at one time. And then you have no-knock warrants, which can be issued, and usually those are issued only if they think the evidence could be destroyed. So if the officers show up to serve the warrant and they knock and announce that it's the police, well, then that evidence could be flushed down the toilet or destroyed in some manner, and they might get away with the crime. Or the other reason they would have a no-knock warrant is if there's possible danger to the officers. They know the individuals living at this residence are armed and they're willing to shoot police or whatever. So they can issue a no-knock warrant where they would break in the door basically, secure everything, make sure everything's kind of detained temporarily, and then serve the warrant and search the premises. So let's look at some of these instances where you might not need a warrant, right? So let's talk about how does a search with consent work. Well, again, I kind of mentioned this already, but searching without a warrant is allowed if consent is given by a person having authority to do so. So it doesn't necessarily have to be the owner of the residence or the car. It could be the person that's operating the vehicle. It could be a spouse that lives at the residence or a roommate. If it's a business, a place of business, it could be a business partner that gives consent, and those type of things. So it doesn't necessarily have to be the individual person that owns the building. It could be a business partner that's actually working at the building, and they can give consent as well. So as with a warrant, however, searches with consent have some limitations as well. Consent must be voluntary. I mean, the officer obviously can't be twisting the guy's arm and threatening him and saying, "You better give us permission to search the place, or I'm gonna, break your arm." They can't force it out of the person. So the search must be voluntary. I'm sorry, the consent must be voluntary, and then the search must be limited to the area for which consent is given. So if an officer says, "Hey, can I look in your trunk?" Well, okay, and you pop the trunk and you give consent, and they can look in the trunk. That's fine, but they don't have consent to look in the center console. Most of the time, officers aren't going to ask if they can just look in the trunk. They're going to ask if they can search your vehicle, and that gives them the consent to really look anywhere inside the vehicle, the center console, the trunk, the under the seat, wherever. But it has to be limited to the specific area in which consent is given. What about these pat-downs and frisk, right, or stop and frisk laws that they have in some locations? So one duty of police officers is to investigate suspicious circumstances. This includes stopping and questioning people that are acting suspiciously. The procedures for stopping and questioning suspects are regulated by the same justifications and limitations associated with lawful searches and seizures. It's a little bit more ambiguous. They can kind of use judgment a little bit more, and maybe some officers might use their judgment a little differently than others. And I'll give you an example of this on the next slide. So there's two situations that require a police officer to stop and question individuals. First, to investigate a suspicious circumstance, and we'll talk about that in a moment, or to identify someone who looks like a suspect named in an arrest warrant. So if they're if they get an APB or an arrest warrant for an individual that maybe robbed a liquor store, and they're driving along and they see somebody that looks like the person that just committed this crime, they can obviously stop that person and start questioning them. If it's a suspicious circumstance, that can be kind of ambiguous as far as what's considered suspicious. But let's look at a few of these. Stop and frisk has been validated on the basis of furtive movements, inappropriate attire, carrying a suspicious object such as a television or a pillowcase, vague, nonspecific answers to routine questions, the refusal to identify oneself, or simply appearing to be out of place. So again, what looks out of place to one person might not look out of place with another, but I mean, if you're If there's a store that's been broken into and somebody's walking out carrying a big screen TV, that's suspicious, right? The officer then has the opportunity to kind of stop that person, frisk them, ask them questions, and see what's going on. What about a search following an arrest? Well, every lawful arrest is accompanied by the search of the arrested person to protect the arresting officers and others and to prevent destruction of evidence. Any weapon or dangerous substance or evidence that's discovered by the search can be seized. In Kimmel versus California, that established that a search incidental to a lawful arrest must be made simultaneously with the arrest and must be confined to the area within the suspect's immediate control. And we're going to talk about what immediate control means in a moment. But it has to be done simultaneously. In other words, you can't make the arrest and then see the guy walking on the streets a couple days later and search him. That doesn't work that way. It has to be at the same time, and then it has to also include only the areas within the person's immediate control. So let's talk about what immediate control is. A person's immediate control means within the person's reach. The court noted that using an arrest to justify a thorough search would give police the power to conduct something called general searches, which were declared unconstitutional nearly 200 years ago. So in other words, let's go back to our drunk driver example. So the person is pulled over. They've been swerving all over the road. They do a breathalyzer. They find out the guy's over the legal limit. They're going to arrest him for drinking and driving or driving while impaired. So they make the arrest. They pat him down. They can search the vehicle because that was within the person's immediate control. And maybe they find an open container of alcohol or something like that can be used as evidence. But they don't have the right to go 10 miles down the road to where the person lives and search their house too. That would be outside of the person's immediate control. So the Supreme Court added the authority for police to actually search the areas immediately adjoining the place of the arrest. Such a protective sweep is justified when reasonable suspicion exists that another person might be present who poses a danger to the arresting officer. They also do it occasionally if there's maybe a foot chase or something like that, and they think that the person threw some piece of evidence or something out of their pocket into a bush. They can sweep that area as well. And then you have the searches in an emergency situation. So if an officer's walking by a building and they hear somebody screaming for help, they're not going to yell back, "Hey, okay, just hang in there. We're going to run out and get a warrant." By the time they get back, the damage is done. Maybe the person's dead. Maybe something bad has happened, right? Same thing if shots are being fired. They're not going to have to run off and get a warrant to go and search that particular location. They can kind of use their own discretion. All right, so what are the basic limitations for searches? The most important limitation on any search is the scope must be narrow. General searches are unconstitutional. You can't just search somebody because you think they're a bad person. You can't look at them and say, "Hey, we know you're doing something illegal. We don't know exactly what you're doing, but we're going to search your house and find something." Okay? Laws regulating on how and when searches may be legally conducted are numerous and complex, and there's slight variations maybe from location to location, but each officer or crime scene investigator who is responsible for a criminal investigation has to be aware of these laws and operate within them. Any evidence obtained during an illegal search will not be allowed at trial as established by the exclusionary rule. It will be inadmissible. So let's look at some of these rules, especially the exclusionary rule, and then maybe some of the different things that can happen that might make it exempt from being, inadmissible. So the first is the exclusionary rule. The exclusionary rule established that courts may not accept evidence obtained by unreasonable search and seizure, regardless of its relevance to the case. In Weeks v. United States, 1914, the rule was applicable at the federal level. Then Mapp v. Ohio, 1961, made it applicable for all courts. The exclusionary rule affects not only illegally seized evidence, but also evidence obtained as a result of illegally seized evidence, and this is referred to as the fruit of the poisonous tree. So a quick example, I'll make one up real quick. If somebody's house is being searched and the people that are searching it fail to get a warrant, and they come across a laptop. And then as they're going through the laptop, they actually find, hey, in the laptop there's emails giving us the location of where this person hid drugs in a self-storage facility. And then they go search the self-storage facility and find the drugs. Neither one of those are going to be allowed at trial, because if there was no warrant for the computer, the laptop, right, that's not going to be allowed. And then if they use the laptop to get the other evidence or find the location of the other evidence, that's the fruit of the poisonous tree, and that won't be allowed either. So the fruit of the poisonous tree doctrine establishes that all evidence obtained as a result of an earlier illegality must be excluded from trial. Now, there's a couple loopholes here that can come into play. The first one is something called inevitable discovery doctrine. When a search is stopped before discovering a critical piece of evidence, such as a body, right, and the body is discovered later, you have what's called the inevitable discovery doctrine. Basically, this establishes that if an illegally obtained piece of evidence would in all likelihood eventually have been discovered legally, it can be used. So, in other words, if you have the body and it might not have been discovered or whatever, but just from the stench of the body and neighbors reporting from the stench of the body, maybe in the next apartment, um, it would have eventually been discovered anyway. That would be the inevitable discovery doctrine. You also have the good faith doctrine, which establishes that illegally obtained evidence may be admissible if the police were truly not aware they were violating the suspect's Fourth Amendment rights. That's a hard one to get through, simply because most law officers are going to be aware of the Fourth Amendment. It's a pretty important one. All right, so I had to stop and get a little sip there. So what did Miranda versus Arizona establish? We're going to jump into these three cases. I'm going to focus a little bit more on the Miranda, Arizona case, and then I'm going to let you guys do some of the research for the other one. I'll just mention them briefly what they established. So let's take a look at this. In this decision, the U.S. Supreme Court ruled that suspects must be informed of their rights to remain silent, to have an attorney present or a state-appointed attorney if they can afford one, and that anything they say can be used against them. The Miranda warning basically informs the suspect of their Fifth Amendment rights. The Fifth Amendment basically states that no person shall be compelled in any criminal case to be a witness against themselves. So you hear people say this all the time, I plead the Fifth. That's basically what they're referring to as the Fifth Amendment. So in other words, if they say, hey, where were you on this particular date? And if your answer to that can actually basically make you look guilty, then you can say, I plead the Fifth, and you can refuse to answer that question. Okay? So let's look at the merits of this case real quick. Miranda versus Arizona. On March 13th, 1963, Ernesto Miranda was arrested in his house and brought to the police station, where he was questioned by police officers in connection with a kidnapping and rape. After 2 hours of interrogation, the police obtained a written confession from Miranda. The written confession was admitted into evidence at the trial despite the objection of the defense attorney and the fact that the police officers admitted that they had not advised Miranda of his right to have an attorney present during the investigation. He was actually convicted of the crime, but then they appealed it up to the Supreme Court. So after Miranda's conviction was overturned by the Supreme Court, the state of Arizona retried him. At the second trial, Miranda's confession was not included into evidence. They still had enough evidence to get a conviction, and Miranda was once again convicted and sentenced to 20 to 30 years in prison. However, that decision, that Supreme Court decision, basically made it mandatory that all people that are being arrested are read the Miranda rights. So what is the Miranda rights, or the Miranda warning? So basically, I'll back up real quick. You usually see these officers and they have this little card, and they read this off the card when they're arresting somebody. They want to make sure they don't, they cross their T's and dot their I's and make sure they get everything just so. So usually what they're reading is something that says this: you have the right to remain silent. Anything you say can and will be used against it in the court. You have the right to talk to a lawyer now and have him present now or at any time during the questioning. If you cannot afford a lawyer, one will be appointed for you without cost. You can decide at any time to exercise these rights and not answer any questions or make any statements. And then they kind of give the waiver. They ask if they understand these rights as they've explained them. And if they say yes, then they can say, having these rights in mind, do you wish to talk to us now? And if it's a smart person, usually they say, no, I ain't going to say anything. Okay? So they'll wait and get a lawyer. So that's the Miranda warning, and that's basically kind of when officers start reading this to every single person that they're arresting. All right, the last two slides here, and I'm going to let you do the research on the actual merits of the case and the decisions and what they were about. That's your homework. But I'll give you the basically what they established. So the next one is Fry versus the United States. This decision basically helps set guidelines for determining the admissibility of scientific evidence into the courtroom. The Fry standard or Fry test, or what's called the general acceptance test, is a test to determine the admissibility of scientific evidence. It provides that expert opinion based on a scientific technique is admissible only where the technique is generally accepted as reliable in the relevant scientific community. So no pseudoscience, no made-up science, no crazy, techniques that haven't been proven to be effective. They want relevant and generally accepted techniques in the scientific community. Okay, and you're going to do the homework and find all the merits of the case and the decision and what it was about specifically. The other is the Daubert versus Merrell Dow pharmaceuticals. And this case set forth the requirements for analysis used to determine the admissibility of expert testimony. It's now known as the Daubert standard. It's a two-pronged standard that basically states that expert testimony must both be reliable and relevant. So on the reliability end, it kind of takes the Fry standard a little bit further. The scientific theory or technique can be and has been tested. They have to prove that it's been tested. Has it been subjected to peer review? Have other scientists looked at this? What's the error rate? You have to identify the error rate. And then finally, not finally, because there's a couple of things, but what are the standards for controlling this technique's operation? And then it kind of goes back to the general acceptance with Fry, and also the relevancy the information obviously has to pertain to the case. So that kind of takes us through all of the notes here, and I'm just going to say thank you and have a good day. And if you have any questions, make sure you come and see me during office hours.